Good afternoon. One of the hats I wear is that of faculty advisor to the Washburn Law Journal, and I'd like to compliment my staff here today. They have worked very hard, particularly John Rhodes and Troy Larson, to put together a great conference. They've had a lot of good help from Professor Gehring and Donna Vilander, but we all owe them a great debt. Professor Sands gets the award for coming the furthest for our conference. He is a professor of law at the University College of London, where he directs the Center on International Courts and Tribunals at the University College of London. The center seeks to promote international justice, international peace through international justice and the rule of law, and to enhance the effectiveness of international courts and tribunals. Professor Sands has authored two books, Lawless World, America and the Making and Breaking of the Global Rules, from FDR's Atlantic Alliance to George W. Bush's Illegal War in 2005, and the one I started reading last night, Torture Team, Rumsfeld's Memo and Betrayal of American Values, published in 2008. In his practice as a barrister, Professor Sands litigates cases before the International Court of Justice, the International Tribunal for the Law of the Sea, the International Center for Settlement of Investment Disputes, and the European Court of Justice. We're in for a rare treat. I give you Professor Philippe Sands.
Thank you very much, Professor Duncan, and I'm truly delighted to be here and to meet with Tom Romick, who's emerged as something of a hero for me in relation to much of his work over the past years. I'm absolutely delighted to be in Kansas for the first time. So are my kids, because Kansas in our family is associated with a particular movie that they are extremely fond of. Let me begin with a quotation from a movie. The principle of criminal law in every civilized society has this in common. Any person who sways another to commit murder, any person who furnishes the lethal weapon for the purpose of the crime, any person who's an accessory to the crime is guilty. How easily it can happen. There are those in our country too who today speak of the protection of country, of survival. A decision must be made in the life of every nation at the very moment when the grasp of the enemy is at its throat. And then it seems that the only way to survive is to use the means of the enemy, to rest survival upon what is expedient to look the other way. Well, the answer to that is survival as what? A country isn't a rock. It's not an extension of oneself. It's what it stands for. It's what it stands for when standing for something is most difficult. Before the people of the world, let it be noted that here, in our decision, this is what we stand for: justice, truth, and the value of a single human being. Now, some of you will recognize that as the closing scene from the 1961 Oscar-winning movie Judgment at Nuremberg, starring the great Spencer Tracy as Judge Dan Hayward, handing down the judgment of a United States military tribunal in a trial against Nazi lawyers. The principle underlying the judgment in the case in the movie was simple but significant. Any person who furnishes the lethal weapon for the purpose of the crime can be guilty of the crime itself, and that can include the lawyer who furnishes the legal advice. The film was largely based on actually a real series of trials held in 1947 under the auspices of the U.S. military tribunal in Nuremberg. The cases were known as the Justice Trials. The case of the United States versus Joseph Altstetter was later made into the film, in which the chief consultant of the movie was none other than Telford Taylor, chief prosecutor at Nuremberg and later on professor of constitutional law at Columbia Law School. To be sure, and it's important to stress this, I can't stress it enough, it would be entirely wrong to draw any sort of substantive analogy between what happened in Germany in the 1930s and the 1940s with what has happened more recently in the prosecution of the so-called War on Terror. What is pertinent, however, is to consider the underlying principle. In what circumstances does a lawyer cross a line? A line that separates bad legal advice from unprofessional or unethical legal advice, or the line that separates unprofessional legal advice from advice that may give rise to criminal responsibility. Against the background of recent stories of detainee abuse at Guantanamo and elsewhere, watching the film Judgment at Nuremberg after a gap of many years prompted in my mind a number of questions. What had motivated Telford Taylor and his colleagues, ironically enough in the US military, to go down the path of trying to make an example of the lawyers that the US military considered to be most responsible for some truly heinous crimes? And could the principle apply to the most senior lawyers in the administration of President Bush, who had drawn up, approved, and overseen the application of new interrogation techniques which on their face violated international laws? In 2005, I published a book entitled Lawless World, which described how the administration of President Bush, often assisted by the government of British Prime Minister Tony Blair, had systematically undermined a great many of the rules of international law that the United States, more than any country in the world, had put in place. One chapter of that book addressed Guantanamo, how the administration had led the US military into an embrace of cruelty in the name of military necessity. I don't need to remind people in this room, I'm truly honored to be with you today, that in so doing, the administration abandoned, completely abandoned, President Lincoln's notable determination made in 1863 that military necessity does not admit of cruelty in any circumstances. This act of the administration is reflected, to my mind, most clearly in a memorandum dated 27th of November 2002, written by William J. Haynes II, Jim, as he's known to his friends, the General Counsel to the United States Secretary of Defense, a memo addressed to Mr. Rumsfeld. It was entitled Counter-Resistance Techniques. Mr. Haynes recommended that the Secretary should authorize 15 new techniques of interrogation. A few days later, on the 2nd of December 2002, Mr. Rumsfeld approved that recommendation, and alongside his signature he wrote notoriously, and I quote, "I stand for 8 to 10 hours a day, why is standing limited to 4 hours?" End of quote. This scrawled response to one of the recommended interrogation techniques, the use of stress positions, standing for periods of up to 4 hours, has of course given the memo a certain notoriety.